Hello, everybody. So now we're gonna get started with the A201. We have already completed the B101, which is the standard form of agreement between the owner and the architect. We also did the C401, which is the standard form of agreement between the consultant and the architect. And we're gonna go through the A201. Hopefully, in a few sessions, it's gonna take several sessions because it's very long. But before I go there, I wanted to show you kind of why we're doing the A201 and where it fits in relationship to the rest of the contract. So welcome, Miranda. So the A201 fits within the rest of the contracts as follows. So the B101 is architect and owner. We spoke about it already. Then we got C41, architect and consultant. We spoke about it already. But when construction begins, construction is when a 8101 is signed on a traditional delivery method called design, bid, build. When an A101 is signed and we're going to begin construction, there is a general conditions of the contract that controls sort of all of the parties within the project. It's that general conditions of the contract that we are going to be sort of being the construction administrator of. That's one of our duties as per the B101. And I will touch upon the A201, but before I even touch upon the A201, I will touch upon things that are within the A201 that we'll be talking about. Um, but you guys understand that the A201 is for the design bid build, and the design bid build is our traditional delivery method. So I'm gonna read these key attributes real quick. Is for use when the owner's project is divided into separate contracts for design, which is architect, and construction, contractor. Suitable for conventional delivery, which is the design bid build. The owner retains the architect. The architect and her consultants prepare drawings and specifications. The architect assists owner in obtaining bids, proposals, and then owner awards the contract for construction. The contractor and sureties obligate to owner for bid, performance, and payments bonds. The contractor and subcontractors build the work. Contractor here and the subcontractors build the work, right? And the versions of the AIA documents are involved in here are the A101, A201, A401, B101, B103, C401. And they developed specifically for use on sustainable projects are also available, which is that A101 for sustainable project SP. So those are all of those. The A201, the A201 is not in itself a contract. It's the general rules for by which the game of construction is to be played, if you want to call it that way. All right, it's not a contract. It's referenced on the B101, it's referenced on the A101, and on the C401, but it's not on itself a contract. But before we go through the A201, I wanted to touch upon a few things. One of them is that within the A201, there is this thing called change orders. A change order is a modification to the contract that's being delivered by the contractor for the owner on the project. Modifications can be made in three ways: change order, construction change directive, and supplementary instructions. The change order, it's a document, G701. It outlines what the project name and address is, who the owner is, who the architect is, who the contractor is, and the date of the change order, and the number of the change order. It outlines the costs associated with the original contract as per the A101, it's the original contract. Outlines what the net changes are, either in time, contract sum, or scope of work, in whichever way, but typically it's time and cost. Those are the main ways. And it is not valid until it's signed by the architect, contractor, and the owner. The three of them sign it. And that's an attachment to the A101, which is the contract between the contractor and the owner. We have another document though that changes the contract, is construction change directive. And a construction change directive is slightly different from the change order, in which the main change is it does not need to be sort of approved or agreed upon when it comes to costs by the contractor. Is a change that must happen, and we don't care about the costs associated with that change. We will discuss those costs later, either through mediation, arbitration, or litigation, or even by the initial decision maker, which you might know who it is by default, which is the architect, IDM. And it again is almost like a change order, but again, the change order is kind of agreed upon by everybody. Everybody knows it, everybody agrees upon it. It happened, it's signed. It's not valid until it's signed. But this one, though, when signed by the owner and architect and received by the contractor, this document becomes effective immediately as a construction change directive, and the contractor shall proceed with the changes described above. So it is telling you right here, architect and owner, architect and owner agreed on the change. Contractor, do it. You do it. That's it. End of the story. So, and he does say here that contractor signature indicates agreement with the proposed adjustments in the contract sum and contract time set forth in this CCD. So this signature here means this is a change order and I agree to it. If the contractor does not sign it, it is not a change order. I mean, it is a type of change to the contract, but it has not been effective as a change order on the contract yet. Meaning he doesn't necessarily agree to the cost. He can argue it, he can fight it, he can go to court with it, you know, but it is a change effective by the owner and the architect. Okay. Is this confusing? I mean, I have a hard time explaining it. So change order is agreed upon by everybody. Construction change directive, the only two people that need to agree on it is the architect and the owner. That's it. Nobody else needs to agree to it. And the contractor shall do it. He must deliver it, whatever the change is. Then we get this other change. It's not technically a change because it doesn't change the contract sum and the contract time. That's why it's called an architect supplemental instruction. And it is a change that doesn't have any cost or time implications to it. If the architect says that wall is going to be painted blue, and the drawings say that it was going to be painted red, and the cost of red paint versus blue paint is the same, and the owner has no issues with it, the contractor shall just paint the blue, and here's how you paint the blue. Done. Nobody else needs to sign it. Nobody else needs to agree to it. Only the architect. And it is because, if you remember correctly, on our standard form of agreement between the architect and the owner, there is a clause that says decisions rendered by the architect on aesthetics is final. Any aesthetic decisions, design decisions that we make, we have the authority to make them. All right. And they are final. So that's why this is aesthetic and design look that doesn't have any cost implications. All right. Now, I then want to talk to you about this other document called instruction to bidders. There's another one that's called like instruction to for proposals for people that, you know, but this document happens right there when we're about to get a A101 signed, and we are supposed to be assisting the owner in getting bids or proposals. All right. So this one is, you know, represented by the owner and the architect, and it just really starts telling them the rules of the game to which they must abide in order for the proposal to even be considered. Like any requirements, bidding requirements, anything that we want them to take under consideration. And there's some standard stuff, and there's some other things we could add to it. I'm not gonna go through it, but anybody that's taking the construction evaluation exam must go through this, must go through the change order document, it must go through the construction change directive document, it must go through the architect's supplemental instruction document. But I'm just trying to separate the game right here. The game to construction got started. It's a whole new set of parameters by which we gotta abide. And the B101 tells us that we gotta go by them. We gotta abide by them. And that's this, the instructions to bidders is not a contract itself. It's really like the rules by which the proposed bidders or proposals need to go by, dates, important dates, and things like that. If they don't go by these, their proposal or their bid may not be considered. In fact, it may not even make it to the table, right? Because we got a checklist, and this helps us with that checklist of things that they gotta abide by. If they're not abiding by it, too bad. I'm sorry. With that being said, we understand that we are right now on A201 zone, and we work for the owner in administering the contract. I'm going to now get started with the A201. First thing I said about the A201 is that it is not a contract. It's not a contract. It's terms and conditions, general conditions. In fact, the very end, page 38, there's no signature. There's no signature. Nobody signed anything. Why? Because if it was, and then the architect had to sign it, and the contractor had to sign it, and the owner had to sign it, it will establish a duty and responsibility from the owner to the architect to the contractor that doesn't exist. Like the contractor should not have any duty to the architect, and the architect should not have any duty to the contractor. There is no relationship between the two other than the fact that we are administering the contract. All right, so that's really where we're at. Make sense? That being said, let's get started. So document A201 2017, general conditions of the contract for construction. Establishes right here what the name of the project is, address, location, who the owner is or legal entity, who the architect is, and it goes right into table of articles, just like any other of the A1, the AIA contracts that we have. And the table of articles says general provisions, who the owner is, establishes what the owner is. There's an article for the owner itself so that we define that entity very well. There's an article for who the contractor is, sorry, yeah. And the architect. Now, why is the architect even placed last on this list? I mean, it's not last, there's the subs, but it's third. Any idea? I mean, this is, you can make it up. It doesn't have to have a real reason. We don't know that. I don't know that. I can infer it. Miranda, what do you think?
Maybe I just thought it'd be order of importance.
Well, yeah, there is a contract that we're trying to administer for the owner and contractor.
Mm-hmm.
So the main parties to this project are the owner and contractor when construction begins. We're not really the stars here. We're merely a representative of the owner in relationship to the project because we've designed it. That's it. Then we got the subcontractors who really don't have much to do with the owner anyway because they work for the contractor. And then we got, you know, an area that says construction by owner or by separate contractors. Like he may hire another contractor to do something else. And he speaks about changes in the work, which we spoke about, construction change directive, change orders, and supplemental instructions. We talk about time. There's this thing that people use a lot. Time is of the essence. Contract is essentially all about time and all about money. There you go. Payments and completion, money. When are we supposed to be done by and how are we supposed to pay that? Protections of persons and properties as far as about insurances when it comes to, you know, commercial liability, general liability, and things like that. Then there is this other one called insurance and bonds. Those are, you know, about performance bonds and bid bonds, which are different things. I want you to be familiar with those two terms, bid bonds and performance bonds, and what they are all about. Then there's this clause, right, this article right here about uncovering and correction of work. We live in an imperfect world, and things do need to be corrected sometimes. So how do we deal with those, and how do we uncover them to know whether they're actually done right or not, right? Then there is the miscellaneous provisions, terminations or suspensions of the contract, claims and disputes. Hey, sorry. Just like any of the others, all the contracts, claims and disputes is one of the last articles. We go right through, and then we have an index that uses all of these terms and tells you where they are located. I would say you should all be familiar with all of the terms that are in here, and most of the time they do get explained within the A201. But I want to understand what they are, what do they mean, and how do they work. Terms like substantial completion, final completion, change orders, indemnification, initial decision maker, right? Those are very important terms that we got to know. Stop work orders, non-conforming work, application for payments. That's another document that I should show to you guys, and I will eventually show it to you. But application for payments are very, very, very critical. I'm gonna try to fast track through this really quickly so that we get right to the middle of things. All right, so we're gonna start now with Article 1. Welcome, Prasanna. So you didn't miss much, and this is actually being
Hey,
recorded. It's gonna be on our, I guess, ARE Success channel, if I want to call it something.
yeah, I have a test
And
Friday.
I'm sorry.
I have practice test this Friday, practice management.
Perfect, perfect. I hope you've listened to all of our B101 and C41 videos, and let's try to speak after this session to see if there's a time we can connect so that we can kind of give you a little competitive advantage on the test. Okay.
Oh, great. Sounds good.
All right. So Article 1, general provisions. 1.1, basic definitions. So the contract documents, very, very important, both for practice management, project management, and construction evaluation. The contract documents are enumerated in the agreement between the owner and contractor, here and after the agreement, and consist of the agreement, conditions of the contract, either the general or supplementary conditions, and other conditions, drawings, specifications, addenda issued prior to execution of the contract, other documents listed in the agreement, and modifications issued after execution of the contract. A modification, which is a written amendment to the contract signed by both parties, a change order, a construction change directive, or a written order for a minor change in the work issued by the architect. Unless specifically enumerated in the agreement, the contract documents do not include advertisement or invitations to bid, instructions to bidders, sample forms, other information furnished by the owner in anticipation of receiving bids or proposals, the contractor's bid or proposal, or portions of addenda relating to bidding or proposal requirements. And there is a very nice diagram. I'm going to try to find, you guys have seen it, is that sketch which shows all of the contract documents. It is on our very nicely put together project resource manual book. I believe I have access to it, so I'm going to try to pull it up real quick so that I can illustrate what the contract documents are. We're very graphical people, so seeing it will make much more sense than actually stating it. Project resource manual. Project resource. You know what? I can actually Google it real quickly. If anything. No, you guys cannot see Google, right? No. Okay. So let me see. I have it. I must have it readily available. And project resource manual, project resource manual. Sorry about that time. Um, project resource manual. Okay, project resource manual. I always have a hard time finding it. Do you guys recall what page it is? Because it will take a while. If you do, let me know. If you don't, I will just keep going. I'm sorry about that. It's just it's a very nice diagram, and I think it's worth showing. Yeah, my computer actually is kind of freezing. I'm trying to the speed race through it. Okay. Oh, I must have passed it. Let's go through the beginning. And the project resource manual is an incredible asset for you for practice management and project management and construction evaluation. It does talk a lot about other documents. They call it, I think, the AGDC or something. It's like another type of contract document that's not done by the AIA. It's actually done by the Construction Specification Institute, I believe. Um, but I wouldn't want you to try to read those because it would really confuse you. Just like I wouldn't want anybody to mix and match different contract documents because they're not gonna be coordinated. Right. I thought I could just really find it quickly, but I can't. I'm typically good at finding this. Sorry, guys, I cannot find it. And by the way, there is the AIA and the EJCDC. Those are different contract documents. Well, the work contract documents shows up a whole lot in this thing. Now, one thing, while I'm doing this, I want to teach you. If you're trying through the exams, if you're trying to find a word like this, you will lose time. You will waste the whole thing. So, like some of the provided documents, I want you to be familiar with them and where and what page things are, because trying to navigate through the PDF search engine situation, it's not gonna be good. At least know how close or how far from each of the contracts things are, so that if you have to reference something on the resources that are provided that are actually like well-known resources, like let's say the IBC or um, a contract and things like that.
Darwin, it's on page 197.
197. So we just go here and then
Or it's figure 5.1-A.
let's see. One of the advantages and disadvantages of this. What's the figure again? Figure what?
5.1 dash A.
Ta-da! And here's our beautiful baby. It is very illustrative of what the contract documents are, but it's also confusing. So you got to kind of look at it closely and really pay attention to it. But contract documents are from here all the way to here. Okay. So as I said on the A201 is the contract drawings, the specifications, the contracting requirements, right? I believe. Yeah, all of that. 3 chunks. And then going back here, that's it. Now let's talk about, thank you so much, Miranda. So now we're going to talk about the contract. The contract documents form the contract for construction. The contract represents the entire and integrated agreement between the parties hereto and supersedes prior negotiations, representations, or agreements, either written or oral. The contract may be amended or modified only by a modification, which we have already spoken about, change orders and so forth. The contract documents shall not be construed to create a contractual relationship of any kind between the contractor and the architect. Remember that? Or the architect's consultants, between the owner and a subcontractor or a sub-subcontractor, between the owner and the architect or the architect's consultant, between any persons or entities other than the owner and the contractor. Got it? So most of the time, if not almost every time, when there is a question on the construction evaluation exam about who's at fault and what and so forth, it's either owner or contractor. Either owner or contractor is going to have to pay for whatever that situation or change is. Okay, Miranda? Owner or contractor. Later on, we'll determine whether really the architect was the one that had an error and omission and he will pay. But for the time being, it's between the owner and the contractor. So the architect shall, however, be entitled to performance and enforcement of obligations under the contract intended to facilitate performance of the architect's duties. The work. The term work means the construction and services required by the contract documents, whether completed or partially completed, and includes all other labor, materials, equipment, and services provided or to be provided by the contractor to fulfill the contractor's obligations. The work may constitute the whole or a part of the project. A little bit or a lot. Is the installation of a nail part of the work?
Yes.
Is putting a handle on a door a part of the work?
Yes.
Is the owner's little mat that says welcome home part of the work?
No.
Good job. It's not. That's actually added after the fact. Well, the answer really will be, is it in the contract?
FF&E. I'm kidding.
If it isn't, yeah, if it is in the contract that the contractor shall provide that part of the work. Okay. Again, services required by the contract documents. So the answer then, that was a trick question. The answer should be, is it on the contract documents? Because it may be not only a construction, but also a service. You know, it may be vacuuming the whole building after completion. That's actually a service, not even a work, you know. So section 1.1.4, the project. All right. Don't confuse the work with the project. The project is the total construction of which the work performed under the contract documents may be whole or a part, which may include construction by the owner and by separate contractors. All right. Then we go with section 1.1.5, the drawings. The drawings are graphic and pictorial portions of the contract document showing the design, location, and dimensions of the work, generally including plans, elevations, sections, details, schedules, and diagrams. Please, 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 please know this definition. Miranda, will you say you've encountered this in some way or another? Understanding what this definition is?
Definitely on CA.
I'm sorry, Abelis?
Yeah, it's definitely something that you have to encounter on construction evaluation.
Yeah, you will encounter understanding the definition you will encounter on construction relation, but I think also it's a practice management and project management thing that you will find. Okay. So again, I mean, I would memorize this thing. The drawings are the graphic and pictorial portions of the contract document showing the design, location, and dimensions of the work, generally including plans, elevation, sections, details, schedules, and diagrams. Then we go to section 1.1.6, these specifications. So you see how we have the graphic and pictorial, then the specifications are that portion of the contract document consisting of the written requirements for materials, equipment, systems, standards, and workmanship for the work and performance of related services. Is in writing, right? Is the door holder, right? The big book that we all kind of have seen laying around in the offices. Then we go and define what the instruments of service are, which we've spoken about on the B101 and the C401. Instruments of service are representations in any medium of expression now known or later developed of the tangible and intangible creative work performed by the architect and the architect's consultants under their respective professional services agreement, B101, C401, right? Instruments of service may include, without limitation, studies, surveys, models, sketches, drawings, specifications, and other similar materials. Very important.
I have a quick question.
Go for it.
When they refer to surveys on the instrument of service, do they refer to the kind of like the site survey, or they mean to like existing condition survey?
That's a great question. So surveys with the S, multiple one, does refer to or may refer to an instrument survey done on the site, by a professional land surveyor, or a site survey done by the team. And existing conditions is a type of survey, or a programming type of survey where you actually go and do a head count and talk to people and gather information about the facilities. All of those may be included within that studies. I mean, surveys, right? That's all. It's not one or the other. It's all. It may be. It's any of them. Any of them qualifies as a survey. All right. It may be any type of, like, it may be a survey of, like, okay, how many females and males are there, on that particular facility? How many toilets do they have? How many computers do they have? That type of survey also is included in here. All right. Again, models, sketches, drawings, and specifications, and other similar materials. Those are all instruments of service. And it says known, meaning they have already been developed, but also some that will be developed throughout the process, which may be architect's supplementary instructions, right? Construction change, any sketches, right? The SKs that we know. And even on the change orders, we may have something like that we have to sketch on. We are the authors. This is very, very nicely put in here, because it talks about intangible creative work. I mean, we're creative entities, creative beings. I mean, that's what we do. We design, like, that's our stuff. That's our bread and butter. So it defines that in here so that, and it's the same definition as the one that we have in the B101 and the one that we have in the C401, should they be any. Because we got to make it clear here to the contractor and to the owner that this belongs to us, that is the architects and architects consultants. All right. And as you know, when there is a termination, there is a termination fee and a instruments of service fee a licensing fee for those instruments of service. It may be a napkin sketch, guys. It doesn't matter what it is. Section 1.1.8, initial decision maker. You guys have heard of this one. Let's talk about it. The initial decision maker is the person identified in the agreement to render initial decisions on claims in accordance with section 15.2. The initial decision maker shall not show partiality to the owner or contractor and shall not be liable for results of interpretations or decisions rendered in good faith. That's it. And the agreements will actually say who the initial decision maker is. Typically, it's the architect, okay? So 1.2, correlation and intent of the contract documents. I want you to really, really, really pay attention to this because sometimes we get into the agreement of whether the spec is right or the drawings are right. The drawings call for a storefront. The spec is not calling for storefront. What do we do? What do we do? What, like, there's all these issues, coordination issues. Okay, so I want you to really pay attention. I'm gonna read it carefully. The intent of the contract document is to include all items necessary for the proper execution and completion of the work by the contractor. The contract documents are complementary, and what is required by one shall be as binding as if required by all. Performance by the contractor shall be required only to the extent consistent with the contract documents and reasonably inferable from them as being necessary to produce the indicated results. Any questions on that, guys? In other words, what he's saying is, well, doesn't matter that the specification didn't talk about the storefronts, the drawings that speak about the storefronts, you got to provide storefronts. There are some drawings showing storefronts. And even if they don't, they're not correlated or coordinated properly. If one requires it, it requires it by all of them. What's required by one is binding as if required by all. Here's the thing, guys. This is why I'm gonna pitch in a few words of advice. If you don't mean it, don't draw it. Okay, as architects, if you don't mean something, don't put it on the drawings. If you don't really mean to do something, don't put it on the drawings. It doesn't matter that it looks like a good idea, it looks cool, it's great. Because the moment you put it on the drawings, it's binding. The brick pattern that you put in there, the color of brick that you put in there, the cute storefront, the cute overhangs, all that stuff. You know, the little canopies that you're doing, or whatever it is, it will become binding on the contract. If you don't want it, don't draw it. That sheet is better taken out of the set than put in there if you don't want the contractor to build it. Again, the contractor, if they actually look at the drawings, they're actually looking at them for scope of work. And everything in there is a line item that they're gonna quantify, price, and put a price tag and a time tag too. Everything in there. I mean, you should assume that everything in your drawings is gonna be built. Whether you're like, they're probably not gonna build it, they're probably not gonna do. No. You don't do that. What you design, assuming it is going to be built, expect it to be built. It is their duty as contractors that they will be building this. So make sure that you're very mindful of it and very deliberate about what you're putting. Even those general details that we throw in some drawings, like if they're not applicable, I'd rather not have them. Okay, and this is general advice beyond the AIA or the NCAR. It's kind of my 2 cents of that. I'd rather not have them if they're not going to be applicable. You know why? Because they are going to become a question. Do you want to get a phone call about that roof detail on a project that is for a deck that doesn't really require a roof? Do you even want to have to answer that? Do you want to answer it from the contractor? Do you want to answer it from the owner? Do you want to answer it from the building inspector? Oh, I'm not proving that because you're putting a roof in it. No, it's just a deck. The moment you put a roof on it, it's gonna become, I'm just throwing a lot of contextual information so that you understand. You got to be deliberate, because what's required by one is binding and as though it is required by all. Okay. Even that little cute thing you put in there. Oh, that's a great Revit family. Well, if you don't mean it, don't draw it. Don't put it. Find one that looks like the one that you think should be there. Right? Because you have some cute furniture in there. Don't show it. If furniture is not included, don't show it. We always mark up drawings and say, don't show that, don't show this, don't show that. Why? Because we're looking for scope of work, scope of services. Not relevant. Not relevant how cute of the layout you did for the contractor. All right. That will be a design drawing for the owner, separate, not for the contractor. All right. And that's why we have schematic drawings, we have bidding drawings, we have construction documents, we have a bunch of different things. We have, permit sets, right? Because there are things that the building inspector doesn't care about. Sometimes for permit set, you can just show a sheet, one sheet. Here it is, go. You don't need to show the whole set, you just show exactly what you need so that you can get the permit. The rest of the information is provided to the contractor so that they can build the building, all right? And there's no one size fits all. That's why we have different sets. All right, so that's clear. Nobody has any questions. I hammered it down very hard. Miranda, anything?
Yes. So if there's a discrepancy between your specifications and drawings, is it the responsibility of the contractor to question it, like in an RFI, or okay, or do we just pick it up in a shop drawing review?
So you're gonna see later on, and I'm gonna point it out and hammer it down again too, like that. There is a definition for who the owner is and who the contractor is in here, and it's gonna say there, and I don't know these contracts by heart, but it does say it. That if the contractor knows of any discrepancies in the work, they shall notify the architect immediately. That's it. They have to let the architect know. It may be just like, hey, you show this brick here, and then you show this brick there, and they're like the same floor plan, and blah, blah, blah. Request for information, RFI number 1, RFI number 2, RFI number 3. You know what? When in doubt, just ask. If they were to know about it and omit it, they become liable for it. Isn't it funny? Because you saw something, you didn't say anything about it, and you knew about it. That moment, you own it at that point. So.
Let's say if there's a mistake on the architect's drawings that doesn't affect cost, scope, or anything of that sort. Can you just pick up that mistake on a shop drawing? Like, let's say if it's a different color or a cap type for a mullion or something.
Well, the contract documents are not perfect. That's one thing, right? So yeah, you could pick it up on that end, see it, and be like, oh no, that's really not the color that they ended up deciding with. They probably saw some not the most up-to-date drawings or whatever, right? You can pick it up there and say that's not the color that we wanted. But guess what? That may become a change order if there's a cost implication to that color, and you may have to respond to that as an architect because that was an error or omission of you.
Right.
But the contractor shall let you know as soon as he sees it, because the shop drawings get reviewed by the contractor. In fact, if the contractor hasn't seen it, you should not even see it. You should not even open it. It should have a stamp that says review and approved by the contractor before you see it. Okay.
Thanks.
All right. So performance by the contractor should be required only to the extent with the contract consistent with the contract documents and reasonably inferable from them as being necessary to produce the indicated result. Okay. The invalidity of any provision of the contract documents, which is kind of what you were talking about, shall not invalidate the contract or its remaining provisions. Well, guess what? That color wasn't right. We ain't doing the whole thing. No, you're still doing the whole cabinet. You're just gonna have to change the color and let me know if there's a cost associated with it. All right. If it is determined that any provision of the contract documents violates any law or is otherwise invalid or unenforceable, then that provision shall be revised to the extent necessary to make that provision legal and enforceable. In such case, the contract documents shall be construed to the fullest extent permitted by law to give effect to the parties' intentions and purpose in executing the contract. We've heard something like this on the B101 already. So then we go to section 1.2.2, organization of the specifications into divisions, sections, and articles, and arrangement of drawings should not control the contractor in dividing the work among subcontractors or in establishing the extent of work to be performed by any trade. Turns out that contractors will just grab the door schedule, hand it out to a door manufacturing company, and start making all of their doors. But hey, wouldn't it be nice to actually see the plans where those doors are gonna go? What if the architect missed one and didn't put that it was exterior or interior? Neither, I mean, we might not even be hired to do that. And they start making all of these interior doors, and some of them need to be exterior. Right? So this is trying to resolve that problem. The contractor shouldn't just be grabbing the plumbing drawings and giving it to the plumber, grabbing the electrical drawings and giving it to the electrician, they should give everything to them. And they shouldn't just be subdividing it in accordance to how we divided our drawings. Dividing our drawings, because the moment you start doing that, then we are being responsible for means and methods of construction and sequencing of construction. If they start grabbing our drawings and say, oh, guess what? We got civil drawings first. That means the civil work needs to be done first. What if we then do the civil first? What if we actually put the plumbing engineering drawings first? Oh, they got the plumbing engineering. Let's put the pipe. Well, guess what? The pipes need to be attached to the frame. Like so this is just saying right here, the way that we organize our work does not mean you should organize it that way or follow it that way, because we're not responsible for means and method. Remember, reasonable and prudent, the reasonable and prudent. We're not responsible for means and method sequencing, blah, 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 blah. You guys should know that by now. Okay? So that's what that is right there. And it's really protecting us from a problem that has occurred over the years. Unless otherwise stated in the contract documents, words that have well-known technical or construction industry meanings are used in the contract documents in accordance with such recognized meanings. So that people don't just infer whatever they feel like it. Like a term in architecture or construction means something and they interpret it as something else. That's your problem. Like, this is what it really means. So it's just trying to say, I mean, contractors should know about construction terms, right? They shouldn't, we shouldn't have somebody that has never done construction being involved in construction. All right, capitalization. Hence, terms capitalized in these general conditions include those that are specifically defined, the titles of numbered articles, the titles of other documents published by the AIA, by the American Institute of Architects, okay? They're pretty important ones, okay? That's what it really says. Interpretation. In the interest of brevity, the contract documents frequently omit modifying words such as all, any, that, and. But the fact that the modifier or an article is absent from one statement and appears in another is not intended to affect the interpretation of this statement. There are moments where they say architectural, and then they say the architectural, and then an architectural. It's the same term. It's just they've done it for the interest of brevity. Okay. 1.5, ownership and use of drawing specifications and other instruments of service. You guys know the answer to this. Who is the owner of the instruments of service?
The architect.
Or?
The owner has one copyright to those.
The architect owns it. Who else owns instruments of services?
Consultants.
Consultant.
That's right. The ones that prepare it own it, and they grant a limited license to others. Technically, we are granted a limited license of the plumbing engineering drawings, electrical engineering drawings, fire protection engineering drawings, and so forth and so on. And we transfer that limited license to the owner via ORB 101 contract, because the C401 says we have the right to those for that particular project. And there's a fee that we got to pay the consultants for that license. Should they not be continuing on the job, or should we not be continuing on the job? The owner pays us, we pay them. We all get paid. Okay? So I'm going to read that now carefully. Section 1.5.1. The architect and the architect's consultants shall be deemed the authors and owners of their respective instruments of service, including the drawings and the specifications, and retain all common law, statutory, and other reserved rights in their instruments of service, including copyrights. The contractors, subcontractors, subcontractors, and suppliers shall not own or claim a copyright in the instruments of service, submittal, or distribution to meet official regulatory requirements or for other purposes in connection with the project is not to be construed as publications in derogation of the architects or architects consultants reserved right. We got it. Section 1.5.2, the contractor, subcontractor, subcontractors, and suppliers are authorized to use and reproduce the instruments of service provided to them, subject to any protocols established pursuant to sections 1.7 and 1.8, solely and exclusively for the execution of the work which we have already established, a portion or whole of the project. All copies made under this authorization shall bear the copyright notice, if any, shown on the instruments of service. We got that copyright notice. We update it every year. The contractor, subcontractor, subcontractors, and suppliers may not use the instruments of service on other projects or for additions to the project outside the scope of the work without the specific written consent of the owner, architect, and architect's consultants. So, Alan, you spoke about it. Is Alan around? I don't see him. He left.
Yeah, I'm here.
No. So you spoke about it. You said, can they use it on another project at another location? Nope, absolutely not. They cannot do that. In fact, listening to this as I read it makes me wonder if I have enough clauses in our contract documents internally at my office that protect us from people using it beyond. Now, we're a very friendly team. We're not really trying to go after people or anything like that. But you know what? We're becoming famous, so eventually we might need to protect every design move that we have. But yeah, that's critical. I mean, but then again, even though we may not be using AIA contracts, or you, any of you, this is common law. Like this is becoming the standard of care. So like people know that they should not do those things, right? It's like the canons of ethics. It's the things that you got to do, that you got to obey by, and whether you even know them or not, like they're just ethical, right? Ethical things. So section 1.6, we go to section 1.6. Notice, except as otherwise provided in section 1.6.2, where the contract documents require one party to notify or give notice to the other party, such notice shall be provided in writing, to the designated representative of all of the party to whom the notice is addressed, and shall be deemed to have been duly served if delivered in person, by mail, by carrier, or by electronic transmission, if a method of electronic transmission is set forth in this agreement. Notices are very important, as you guys will see and have heard on B101. There's like this 7 days notice, 10 days notice, 14 days notice, so forth. And they're very important because the clock starts ticking when the person got the notice, not necessarily when you sent the notice, when they got the notice. All right. So that's why it's certified mail, and being delivered by carrier. That stuff is very important, right? Because time is of the essence. So, okay. So notice of claims as provided in section 15.1.3 shall be provided in writing and shall be deemed to have been duly served only if delivered to the designated representative of the party to whom the notice is addressed by certified or registered mail, or by carrier providing proof of delivery. This is very, very critical again. You know, that's why in divorce proceedings or court summons you get served. Like even the police themselves bring the documents to you and they serve it and explain it to you. right? It can't just be like, yeah, I sent it to the mail. Like, no, you gotta get it. They gotta receive it. They gotta get it. So this is very important. So section 1.7, digital data use and transmission. The parties shall agree upon protocols governing the transmission and use of instruments of service or any other information or documentation in digital form. The parties will use AIA document E203 2013, Building Information Modeling and Digital Data Exhibit, to establish the protocols for the development, use, transmission, and exchange of digital data. We've heard of this before. You should read the E203. I mean, it's not so critical for the exams, 100%. Like, you won't really pass or fail because of the E203. I don't think. It's my opinion, but I would say just to read it. So 1.8, building information models, use and reliance. Read carefully. We've read similar provisions to this before, even probably word by word the same one, but there's a reason why they keep repeating it. It's for a new audience. This is now for the contractor, right? We already know about this on the B101, but the contractor doesn't know about this. So that's why one document references the other and connect with each other. And that's why you cannot be mixing and matching, different contracts that don't coordinate properly. So in any use of or reliance on all or a portion of a building information model without agreement to protocols governing the use of and reliance on the information contained in the model and without having those protocols set forth in AIA document E203 2015, building information modeling and digital data exhibit, the requisite AIA document G202, which is another one, project building information modeling protocol form, shall be at the using all relying parties solve risk without liability to the other party and its contractors or consultants, the authors of or contributors to the building information model, and each of their agents and employees. Very important. And it makes me actually wonder, of our own protocols. We have a document like that here at our office, and now we're working with other teams and entities that have their own models. So it means that when they give me the model, I'm using it at my own risk. You know what it means? It's saying they're not liable for the model. They gave it to me. I'm using it. And unless we use a document that triggers or not triggers, but defines the rules of the game for how to use that model, it's on my own risk. Right? So that's very important. Then we're gonna go to Article 2. By the way, I don't think we're gonna go beyond Article 2 today. I think we're gonna get to from Article 2 to Article 3, and then we're gonna continue tomorrow on Article 3. Just giving you a heads up. In fact, I'm gonna take a quick water break. Is that all good with everybody? Great. People on YouTube will not have any water break because I'm gonna pause and continue right after that. But you guys can talk during my pause. All right, Article 2, we're back. Owner. So Section 2.1, general. So Section 2.1.1 says the owner is the person or entity identified as such in the agreement and is referred to throughout the contract documents as if singular in number. It's the owner, but it could be a bank, right? It could be a board of trustees. It could be 20, 30 people. It could be 1,000,000 people. Doesn't matter. The stakeholders, right? So the owner shall designate in writing a representative who shall have express authority to bind the owner with respect to all matters requiring the owner's approval or authorization, except as otherwise provided in section 4.2.1. The act that does not have such authority. The term owner means the owner or owner's representative, authorized representative. Section 2.1.2. The owner shall furnish to the contractor within 15 days. Oh, there you go. That's one of those. After receipt of a written request, information necessary and relevant for the contractor to evaluate, give notice of, or enforce mechanic lien rights. You guys know what a mechanic lien is? Anybody? Igo? No?
Yes.
Miranda?
I know.
Rosanna?
So mechanics lien is if the subcontractors or the architect is not paid for the services, then they can put a mechanics lien, which means that they can own, I mean, they can have portion in the building, or if the owner cannot pay it, he has to sell the building and then pay off those people.
Yeah, kind of. Miranda, do you have any other insight on that?
No, that's pretty much it, but it's the right for the subcontractor, contractor to put a lien on a property, so they do own a portion of it until they're paid.
I wouldn't say that they own a portion of it, though.
Right.
I can kind of
It's
understand.
it's not like they own a portion of it. It's like a hold on the
Yeah.
property where, for instance, I go, if you buy a car, your car, and you use financing from a bank, the bank has a lien on the car, meaning it's not even your car. It's actually partially the bank, and until you finish paying it off, it's not yours. The title doesn't go to you. So the same thing on another note, though, but the same thing happens with a project, right? Project is being done by a contractor, and the owner has to provide the contractor with like titles and informations about that project, where the contractor, if he's not paid, could actually put a hold on that property, so that at the end of the day, I mean, it's a limit. It could be there for life. It could be there forever. So anytime the contractor is going to try to get a loan or a mortgage or something on that property, I mean, the owner, every time the owner is going to try to sell it, they can't do it unless they pay that person. And they call it mechanic because it's for workers, somebody that worked on that project. We basically could put a lien on a property because we're designing on that property something. And if we don't get paid, we'll place the lien. And there is a time for that, though. You can't just place it whenever you feel like it. There's a time from which the contract was breached, or you haven't been paid, or when the disagreement happened. When it comes to payment, can't just be. It has to be a payment. Like you didn't get paid, you haven't gotten paid. Something's going on with payment.
I don't
That's
think
when you.
I don't think an architecture firm would place a lien on a property. We go through a whole different dispute resolution if we're not paid. It's only like contractors, subcontractors, and anybody doing the work on the site.
Well, in that end, why don't we just go to the B101 and try to see if that's the case? If that's the case, that's perfect, because I want you guys to call me out on my stuff. But I do think that we can. So let's just find the B101 real quick, and we're just gonna write the word lien on that document and see what it says. Okay, lien. So the architect shall forward to the owner the following information received from the contractor: consent of surety, if any, to reduction of any partial release, retaining affidavit release. Nope, that's not. Okay, within 15 days after receipt of a written notice from the architect, the owner shall furnish the requested information as necessary and relevant for the architect to evaluate, give notice, or enforce lien rights. Same thing. It's the same thing. And that's under the owner's responsibilities. The owner has to give the architect enough information so that they could, if they needed to, place a lien on the property. This is not for the contractor. This is not regarding the contractor. This is regarding us with them. This is B101. Does that make it clear? Why? Because Miranda, I know your thinking is hands-on work on that property, right? Maybe you're thinking like that, like it's that plumber putting that pipe in there. Hey, I worked on that property. I put my hands on that property. Well, guess what? There is other type of work, and if you don't think that they're equally important to the owner, and I mean to the property, then that's another question. But they're both equally important. The work that somebody there with their hands on that pipe, on that house, gets enforceable rights to a lien. Just like my drawing to that home addition. I drew a home addition design or a toilet addition or a bedroom addition to that property, to your property. It wasn't even to you, it was for your property. That's why we got to get the instruments of service, information about the property, title, all that stuff. We got to get it at the front, which is called initial information. All right? Makes sense? I think Miranda's not satisfied with it.
I still don't agree.
It says that on section 5.15.
But I'm just also like looking at the context of this writing. All has to do with construction.
No,
Like we're talking about
This is
after.
section 5 of the B101, owner's responsibilities.
Mhm.
So the owner has a responsibility to the architect. Within 15 days after receipt of a written request from the architect, the owner shall furnish the requested information necessary and relevant for the architect to evaluate,
Evaluate.
give notice, or enforce lien rights. Then let's go back to the B101.
That's
to the
that's
A201.
That's lien rights. Yes,
Well-
the architect can give lien rights to contractor, subcontractor after giving written notice to the owner.
No, it's a B101.
Architect can also put lien, has a right to put a lien on the property.
He does, but let's just clarify because I know Miranda's looking for a loophole. Read these. The owner shall furnish to the contractor within 15 days after receipt of a written request information necessary and relevant to the contractor to evaluate, give notice of, or enforce mechanic lien rights. Same thing. Why do we have to tell the architect about that if it wasn't for him to be able to use it? I know that's the little ambiguous area in which you get caught up and you're like, no, exactly. You know what I mean? Like, but in the balance, look at it in the balance. Just why is the architect having the right to enforce a lien? He shouldn't have the right to enforce a lien for the contractor. In that way, then he will be acting biasly towards the contractor. And he's
True.
supposed to be unbiased, right? So, and he's the initial decision maker too. Like why, that's why it's B101, A201, B101, A201. You may not even do construction administration for this project. You may do the B101 and not do the construction administration services, but you still have the right to get, you're gonna get paid. You still have the right to enforce the lien.
So then how come we don't have this second line here? Such
We don't.
information shall
You-
include a correct statement of the record legal title to the property on which the project is located, blah, blah, blah. So how come we don't have that for the architect?
Such information shall include a correct statement of the record legal title to the property on which the project is located, usually referred to as the site, and the owner's interest herein. So I didn't write the AIA contract, right? That's the first disclosure. I would say I don't know. But then the other thing I would say to you is I have been hired by somebody that isn't even on my state, even in this place, even in the country, to deliver architectural design services for them for a land that they're about to buy. They haven't even bought it, right? I still do have the right to put a lien, not on that property, on their home, on whatever property they have, on whatever they have, their car, whatever they have. I would proceed to figure out how to file a lien on them. Why? They owe me. They got to pay me.
I just find it curious that we don't have this second sentence.
You know why? Because they might not own the site already. I told you, they might not own the site already. I have so many developers and clients that don't own a land. You know what? That they actually want us to develop a preliminary concept design for them to pitch into the town and to other abutters how this project may be a great project for this community and how they can all partner together to develop this envision. But I still get the right to put a lien on him, on whatever he has, on his
Yeah, once
house.
he gets up. Yes. Okay.
Right?
Fine. Sure.
But he may never develop that project. It may never happen. I mean, there's so many theoretical I mean, they're not theoretical, they're real projects, but they may know. There's one right now I'm dealing with right now. Very clear cut example. He owns one of the lots. The other two lots he doesn't own. We're designing a combined lot of the three. I mean, am I gonna put a lien on those other properties that he doesn't even own? He's trying to showcase how he could potentially develop this so that he could sell it, so that he can make profit and give profit to everybody, right? So that's why it's in there. I think the AIA didn't spare anything and not putting that portion there. I think they know that the owners may not even own that property, but you got to furnish some information, some sort of information, so that I can enforce a lien.
Thank you.
All right, that's good. Are you now really convinced? You're tough. You're a tough-headed woman.
Thank you for explaining it.
Okay, perfect. And I love your question, and I questioned it because if it wasn't there on the V1, it wouldn't be there. By the way, Miranda, it really wouldn't be there at all. You know, they would have it in here, like the owner should give it to the architect, blah 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 blah. It wouldn't be in the V101. So evidence of the owner's financial arrangements. This is a good one. So prior to commencement of the work and upon written request by the contractor, the owner shall furnish to the contractor reasonable evidence that the owner has made financial arrangements to fulfill the owner's obligations under the contract. It's kind of like the pre-approval letter when you're going to buy a house. Like, why are you even at this open house? Do you even have a pre-approval letter by a bank? Can you even buy this property? Don't waste my time. You know, you can't just put an offer without the pre-approval letter, right? You get what I mean? You've already made arrangements to get that pre-approval, to get approved. So same thing is in here. Why? Because we're not talking about little $5 here and there, $10. Construction projects are a lot of money. I mean, they're a lot of money on average. I mean, you grab 5 construction projects on average, they're still gonna be about $500,000 minimum. If you grab one from a little bathroom for $10,000 to an addition of a kitchen for $25,000 to then $1 million house renovation to then a 3-family project for $600,000, $6 million or whatever, it will end up being very expensive, right? So that can bankrupt any contractor if he was to actually finance the job. And should a contractor be financing a job, shouldn't he be getting paid for that? Right? Like a financing fee or whatever. So in that case, he wouldn't need this because he will be the one financing it. But long story short, because that's another topic for another time. But they got to show the contractor that they have made arrangements and they can afford to do this addition. That's a question I even ask my owners too as an architect. Can you actually pay me? Right? That's a very good question. Can you actually pay me? The contractor shall have no obligation to commence the work until the owner provides such evidence. You don't show me that you can pay me, I won't start. I won't start. Why? I'll tell you. If you can't pay me, and I'm now putting the hat of a contract, if you can't pay me, and I proceed with the work, and I start putting my money on that, and my crew on that, which I have to pay, and I will pay these people, then I will have to suspend the work or stop the work for non-payment, sue you so that you can pay me. We go to court. I'm spending legal fees on top of the fees that I have already spent for having my people work on this job, and I'm wasting my time. This is not a place where I want to be, even if I have the winning case. Because it might be 10 years before I actually get paid. What? And you paying out of your pocket to your lawyers, attorney fees, and all that stuff until you get granted that, very contentious award of the prize. It would just not make sense. Why would I put myself into that position? It's just not gonna happen, right? It's like getting in a relationship with somebody that's already married. Like, why? Sorry, that was a crazy toss-up right there. Why would you do that? So the contractor shall have no obligation to commence the work until the owner provides such evidence that they are actually capable of paying. And if commencement of the work is delayed under this section, the contract's time shall be extended appropriately. You got to give me more time. I can't do it. Section 2.2.2, following commencement of the work and upon written request by the contractor, the owner shall furnish to the contractor reasonable evidence that the owner has made financial arrangements to fulfill the owner's obligations under the contract. Only if the owner fails to make payments to the contractor as the contract documents require. The contractor identifies in writing a reasonable concern regarding the owner's ability to make payment when due, or a change in the work materially changes the contract sum. If there's a very big substantial change order, then you're like, hey, listen, this is like a $500,000 change order. I don't think you can pay me that. Like I'm scared. You got it. The owner has to provide it within you know, after that written request, provide that they have the money to pay for that change order. If the owner fails to provide such evidence as required within 14 days of the contractor's request, the contractor may immediately stop the work. I want you to always remember when somebody and who can stop the work. This is a place, a time in which the contractor may stop the work. Okay? There's a substantial change order or something else. It may be that the owner is Jeff Bezos and his wife is divorcing him and his wife is taking, 80% of all the assets. You're like, oh, whoa. You got to provide me with written information showing me that you've made arrangements that you can pay me. Or even be a scandal, or maybe that the company that the owner owns went bankrupt. Whoa. Your company is going bankrupt. I saw it. You filed for bankruptcy. Nope. I'm not gonna put myself into a position in which I'm gonna get bankrupt myself too, because I'm financing your job. You gotta provide me with that. So there's gotta be reasons. The contractor can't just really stop the work. And he has not been paid and things like that. There gotta be reasons, okay? So again, if the owner fails to provide such evidence as required within 14 days of the contractor's request, the contractor may immediately stop the work, and in that event, shall notify the owner that the work has stopped. By the way, he shall notify the owner that the work has stopped. How is that communication going to happen? Can he just call the owner and say, hey, owner, I'm stopping the work today. You ain't got money to pay me. I'm not going to do that. Can he do that?
No, he needs to provide written notice that he's stopping the work.
That's a good one, yeah. But can he just email the owner and say, hey, owner, I'm going to stop the work. You haven't paid me. You haven't provided me with this thing within the 14 days notice. See you in court?
Yes.
No. Communications got to go through the architect. He's got to email the architect. He could CC the owner on the email, but it's going through the architect. The architect's got to be the main person. Got it? Make sense?
Mhm.
Perfect. However, if the request is made because the change in the work materially changes the contract sum under 3 above, the contractor may immediately stop only that portion of the work affected by the change until reasonable evidence is provided. Oh, you know what? I'm not gonna do that $500,000 change order. I'm gonna continue doing the rest of my project, but I'm not doing that until you provide me with evidence that you can actually pay me for that change order. That's fine. If the work stopped under this section 2.2.2, the contract time shall be extended appropriately, and the contract sum shall be increased by the amount of the contractor's reasonable cost of shutdown, delayed, and startup, plus interest as provided in the contract documents. Hey, there's interest, there's shutdown costs, delay costs, startup costs. I think about all those costs. Section 2.2.3. After the owner furnishes evidence of financial arrangements under this section 2.2, the owner shall not materially vary such financial arrangement without prior notice to the contractor. Guess what? The owner showcases that he's got $1 million in funds extra to pay for this. As soon as he provides a bank statement that has $1 million, he takes it out of the bank account and goes shopping, gives it away to his ex-wife or whatever. Can't do that. Do that. No. It may be that that $1 million was actually borrowed by somebody from somebody else, and he's like returning it back. It's just to meet to that's sneaky too, by the way, but they can't do that. This right here is holding them accountable. They cannot be making changes to that. One thing that I've heard people do is that they create an escrow account where all funds needed for that project are placed on there. You've probably heard of the word escrow. Anybody has heard of the word escrow account? It's a bank account that the owner and real estate agents do it a lot. The real estate agency and the owner and everybody kind of has access to, but bonds are not released until they are signed off. by everybody involved. Like you got to provide the escrow, which is a bank or institution, prove that hey, that money is, they can release it, and they release it. I don't know a whole lot on it, so I want you to do research. It's like the word is like, I think it's ESCROW. So then we go to section 2.2.4. Where the owner has designated information furnished under this section 2.2 as confidential, in which we have heard of it, the contractor shall keep the information confidential and shall not disclose it to any other person. Whatever amount of money the owner showcases to the contractor, they can't just be, hey, he's got a lot of money. Anybody can go break in his house. He's got a lot. No, you can't do that. That's confidential. If the owner says, hey, this is confidential information, you cannot disclose it. All right. Now you guys remember this other clause that says, however, the contractor may disclose confidential information after 7 days written notice to the owner where disclosure is required by law, including a subpoena or other form of compulsory legal process issued by a court or governmental entity or by court or arbitrator's order. The contractor may disclose confidential information to his employees, consultants, sureties, contractors, subcontractors, and their employees, subcontractors, or others who need to know the content of such information solely and exclusively for the project and who agree to maintain the confidentiality of such information. That being said, I'm going to leave these in here because there's a lot of mouthfuls in here on the 8201. I'm going to end it here. I know it's 7:40. It's still 20 minutes in my session, but I do still want to be mindful of all of you. It's been a long day of work. And the 801, it's not going to be finished in just a few sessions. It's going to be several sessions for us to finish it. So I want you to digest it, rewatch these, enjoy it, comment, share it, love it. Let me know if you guys have any questions or anything. Subscribe to my channel, click like, and all of that fun stuff. All right?
All right. Thank you so much,
very
Darwin.
much.